These are some practical tips for working with the Office of Legislative Counsel in California. In talking with former staff of the Office of Legislative Counsel, the OLC, over the years, there's some practical tips that were shared with me for those working with the attorneys at the Office of Legislative Counsel. Now, while some of these recommendations may seem obvious, many of them bear repeating. First, a little background. OLC consists of three branches. The largest branch, as you would expect, is the drafting branch, which is the primary work product of the office. There's also an opinions branch that produces confidential opinions for the office's clients. These opinions, which may be written or oral, resemble the format of the Attorney General's opinions. And these opinions can be distinguished from consultations, which are the informal conclusions of a single deputy rather than the formal position of the office. The third branch is the Legislative Services Branch, which provides general counsel services to the two houses of the California Legislature. Now, most Capitol observers know that the Legislative Counsel, Kara Jenkins, and her deputies serve as the attorneys for the California Legislature, but their role is much broader than that. Under Section 10207, Subdivision A of the California Government Code, the Legislative Counsel maintains the attorney-client relationship with each member of the legislature with respect to communications between the member and the Legislative Counsel, except as otherwise provided by the rules of the legislature. As a result, all materials arising out of this relationship, including but not limited to proposed bills and amendments, analyses, opinions, and memoranda prepared by the Office of Legislative Counsel, are not public records, except as otherwise provided by legislative rules or when they're released by the member for whom the material was prepared. In addition, pursuant to Section 10207, Subdivision B1 of the Government Code, the Legislative Counsel maintains the attorney-client relationship with the governor's office with respect to communications between the governor and the Legislative Counsel. Additionally, Section 10233 of the Government Code provides that upon request, the Legislative Counsel is required to aid and assist any member of the legislature regarding bills, resolutions, and measures, drafting them in proper form and furnishing them to the member, along with the fullest information upon all matters within the scope of the OLC. So second, let's turn to some of the suggestions that have been shared with me over the years. You cannot talk with a deputy legislative counsel on another office's request unless you're authorized to do so by a legislator's office or by the governor's staff. Submit any bill draft and amendment request to OLC as soon as possible and well before the deadline so that there's ample opportunity for the attorneys to review background materials and to draft your bill or amendments. Keep in mind that a deputy legislative counsel regularly drafts a dozen or more measures at any one time, and that number could easily reach over 100 measures in the weeks leading up to the bill introduction deadline each February. In the consultative process with a deputy at OLC, you should discuss with the attorney any legal obstacles. For example, whether the proposal might violate the state or federal constitutions, and any procedural obstacles. For example, that the measure would require a supermajority vote in order to be passed by the legislature. Also, share any information you've got that would assist in the drafting of the measure, such as other state statutes and other background materials that explains your policy proposal. Provide any materials that a third party, for example, a lobbyist or interest group, has provided to the legislator's office. If a deputy contacts you, respond quickly, as answering their question or questions assists in expediting the drafting process. Also, help the drafter understand the purpose and objective of your legislative proposal. If they understand the author's objective, they can make sure the language adequately achieves that objective. For legislative staffers, it's important that you not turn the work over to a lobbyist who might be working the bill for a client because the lobbyist represents his or her client, not the legislator who's the actual author of the bill. Remember that the legislative lawyer is impartial in their legal analysis and bill drafting. In addition, everything that you tell OLC is confidential and protected by the attorney-client privilege. So the more information and background you provide to the deputy, the better job they will be able to do in helping capture the legislative intent of your bill. Also, keep in mind that the attorneys at OLC make the determination regarding the digest keys, such as whether a bill is keyed fiscal or the bill contains a state mandated local program or what the proper vote key is. These determinations are based upon provisions of the joint rules, case law, and customs and practices of the Office of Legislative Counsel. Deputies are required to review every draft as though the proposed language will become law. This is somewhat at odds with the legislative process, where it's often understood that a bill is a work in progress and that ambiguities will be worked out as the bill moves through the process. The attorneys at OLC understand this, but they're still required to undergo a thorough analysis to get their draft language approved. Try to be deferential to the deputy's suggested edits, as they're responsible for maintaining consistency of style in the codes. They're also trained in rules of statutory construction. And don't forget that their draft is reviewed by at least one manager as well as a proofreader. Many deputies have drafted many of the meaningful changes to their specified areas of the code for years. If, however, the language must be drafted as submitted, then please indicate that it is negotiated language. Treat the Legislative Counsel deputy's time as valuable. Thoroughly read and understand your drafting request so that you can quickly and efficiently answer any questions or identify where you need to consult with the author, other staff, or bill sponsors about a bill's provision. Again, be accessible to the deputy. Counsel will do their best to complete your request by your deadline, but being able to respond promptly to their inquiries when they're making them will make for a better work product that is returned faster to you. Legislative counsel deputies are your legal advisors, not policy advisors. Counsel can be very effective at presenting different ways of drafting a proposal, but don't rely upon them to solve a policy problem. Others involved in the legislative process, such as committee consultants, are more equipped to discuss the benefits and drawbacks of different policy options. Most bills are not new in the legislature. When drafting a request, try to rely on other models in statute. Let legislative counsel know if your request is based on a current provision of law or a previous bill. They may not always tell you what you want to hear, but that's not their job. Their job is to provide you with sound legal advice, and they always attempt to help. It can sometimes be a thankless job, so gratitude goes a long way. And treat everyone in the legislative process with respect, as I always say, and above all else, be honest in all of your dealings, whether it's the attorneys at OLC or anyone else involved in the legislative process.